Please help support the channel by visiting our Amazon store, affiliate link below. Hey, what's going on, everybody? My name is Matt Jarbo. This is the Mundane Matt channel, and you know, copyright law is something that I do take to be very seriously. It's one of the tenets of being a full-time YouTuber is that you kind of learn these things. You almost become a subject matter expert in copyright law because you have to navigate the tricky field of it, especially if you do gaming videos or you do movie news and commentary or really anything else. You got to know what's going on. But this particular story about who took a photograph, whether it was the photographer who owned the camera or the monkey who accidentally snapped the selfie, has been an interesting case. And so it's now been settled, and who knows where we stand on it yet. Let's find this out together. So PETA monkey selfie lawsuit settled. That's a mouthful. And we may never know if animals can hold copyrights. That's just adorable monkey. Look at that thing. It's cute. PETA announced Monday that it had settled a copyright lawsuit over its unusual claim that a monkey named Naruto, of course it is, owned the copyright to a toothy selfie that went viral. The People for the Ethical Treatment of Animals agreed to dismiss its copyright lawsuit against wildlife photographer David Slater, which claimed that Naruto and all animals can own a copyright in a photography or a photograph or other creative work. Now, I remember I covered this when this first went to trial, or they first issued the lawsuit about this. I think I said back then, and I still kind of want to say now, how can an animal own a copyright on something? It's not like they can enforce it. And I mean, if PETA was suing this David Slater guy on behalf of Naruto, clearly it's to serve their own political interests. I mean, it's like if they won, who would collect the money, right? Would they pay it to Naruto in bananas? Or, you know, whatever that bandana was that the kid wore on the show. I don't even know. But the point is, it's like, it makes no sense. Like, what would they get out of this? It was just a way for PETA to try to get some extra money, in my opinion. That's what they were trying to do. In exchange for the dismissal of the lawsuit, Slater agreed to donate 25% of future gross revenue from the so-called monkey selfie to photographs, or so-called monkey selfie photographs, to organizations that protect Naruto and his fellow Sulawesi crested macaw monkeys in their native Indonesia. And that's fine. That's cool. Like that's it. That seems like a good agreement, in my opinion. All right. Do I feel like the copyright belongs to David Slater? Yeah, it's his camera. He was out taking pictures. You know, monkey took a picture with his camera. You know, it wasn't like the monkey took the damn selfie on purpose, you know, and posted it to Instagram like hashtag YOLO or nothing. This was, you know, his stuff, and he was out there taking photos. So no, I think he owns the copyright to it. I mean, all the cat videos on YouTube, you don't have the cats up in arms trying to get any of that copyright funds from what is it, like Keyboard Cat or whatever, right? Like no, that cat isn't trying to sue his owner for royalties for everything else. So no, it doesn't really apply that way, but I'm totally on board with this guy being able to give back to the organization that protects this macaw monkey and other ones in Indonesia. Go on to say here, this is the history of it. The dispute arose when Naruto took a few selfies of himself looking directly into Slater's unattended camera with a huge grin in 2011. Slater claimed he owned the copyright in the photo because the monkey used his camera and because Slater had set up the shot for the monkey to take, which I agree with. I think that it was his. PETA, again, in my opinion, just very much wanted to beat their chest and try to act like big boys who wanted to collect some money out of this photographer. Sounds like something PETA might do. You know, that or dispose of animal carcasses and dumpsters behind fast food restaurants in Georgia a couple years ago. That actually happened. One of the reasons why I really hate PETA. The heart of the case was whether an animal can be an author of a work and hold the right to sue, called standing, for infringement under the U.S. Copyright Act. PETA sued using the monkey's name and resulting in the name Naruto v. Slater. What I want, if the monkey wasn't effectively trying to sue the photographer, how can PETA assume that he cared, right? If I were Slater, I would just say like, oh, no, it's cool. It's cool. I already talked to Naruto. Naruto gave me full rights to the image. Well, no, he can't do that. He's a monkey. Well, then how can he own fucking copyright? You stupid idiots. Like, that's the whole point. He should have just been like, no. He said it was cool. We have a verbal agreement. He gave me his banana peel as, you know, as a way of signing it or whatever. Like you just sit there and make something up because they sued in his name. And a judge let this go Like, at least let this go further than whatever. It should have been tossed out immediately. But this is the lunacy and probably the lobbying power that PETA has. PETA appeared likely to lose its case if it did not settle during oral arguments before a U.S. Court of Appeals for the Ninth Circuit in July. The three-judge panel expressed skepticism about PETA's argument that an animal can be a copyright owner. Because it can't be? It can't be. It just can't be at all. Saying here, can you point to a U.S. Supreme Court holding that says man and monkey are the same? Judge Carlos T.B. asked David Schwartz, a lawyer for PETA. Oh, yeah, you can't really bring that up, man. Yeah. Be noted that the law only mentions a person having the right to sue for copyright infringement. Now, they probably would have been able to better argue that monkeys are in fact people, especially in our culture, in our country, where corporations are seen as people. They probably have a better shot of arguing that a monkey could be a person, and then that monkey then suing for copyright rather than just skipping over that personhood thing. Although that's a whole other discussion to have. Andrew J. Dewey, Slater's lawyer, blasted PETA's lawsuit as frivolous. Monkey see, monkey sue will not do in federal court. That's a horrible pun, dude. That's a horrible pun. Horrible pun. Funny. Utterly horrible. Dewey told the judges it makes no sense to allow a monkey to sue for copyright infringement, especially because the monkey is not actually the monkey can't actually say anything. Now, what we would need in order to settle this debate would be Dr. Dolittle. But sadly, that Robert Downey Jr. movie doesn't come out until 2020. So we're kind of hosing that deal. Although that would be a great setup for that at all. That'd be a great, that's to be the plot of the new Dr. Dolittle movie. Is the llama suing for copyright infringement. And Dr. Dolittle is in fact his attorney. You know, he went to online law school and everything else. The case became so disputed that Wikipedia now has an entry called Monkey Selfie detailing the saga, and the U.S. Copyright amended its online guide on what isn't copyrightable and now lists a work by Monkey as not copyrightable. At least PETA, okay, listen. As ridiculous as it was what PETA did, you can at least sit there and argue that they've accomplished something. We've now established in the Supreme Court of the United States that monkeys are not allowed to copyright their own photos. Meaning, if you want to make a lot of money, all you have to do is go out to the jungle and hand a monkey, a camera. But I also want to kind of point out here, this didn't happen in the United States. This didn't happen in the U.S. This happened in Indonesia. So why didn't PETA sue Slater in the country where Naruto is from? I feel like there was a gross overstep of the legal system here, and the fact that it was even able to get this far, I don't know how. I just simply don't know how. It does say here, though, that the Ninth Circuit previously ruled that whales and other ocean creatures cannot sue for oceanic violations of environmental laws in Cetacean versus Bush. The decision probably doomed Naruto's case. Yes. Probably did. Entirely probably did. This is one of the craziest stories I've ever heard. It is. It's so stupid. This monkey is utterly adorable. It is totally adorable. Totally cute monkey. And I'm glad that, the case has been settled. And I'm glad that any future, earnings, 25% of the earnings will definitely go to the organization that is making sure that this dude and his homies are totally looked after. So that part I'm cool with. But just the fact that it was allowed to get to where it got to really shows you the amount of money PETA has in order to pursue these kind of frivolous lawsuits. And it's just another reason why that organization should probably be dismantled as much as it possibly can. It's clearly grown too big for its britches when it can sit there and actually get a lawsuit about a copyright infringement over a monkey photo in front of the Supreme damn Court. Hey guys, that wraps up this video. If you'd like to leave a comment, please do so below. I love to read your guys' input. Be sure to hit that thumbs up button. It really does help me in the YouTube algorithm. If you want to support the channel, there's the Amazon affiliate store, there's PayPal, there's Patreon, there's Bitcoin. And if you're bored and you want something else to watch, check out 3 Buck Theater up here. My name is Matt Jarbo. I will talk to you guys later. Have yourself a wonderful day. Peace out.